Good morning and welcome to the fifth meeting of the Education and Skills Committee in 2020. Can I remind everyone to please turn their mobile phones and other devices to silent for the duration of the meeting. Our first item of the day is a declaration of interest by our new committee members. Before doing so, can I pay tribute to Liz and Smith and Alison Harris for their contributions to the committee's work. I understand that Liz is the longest serving member of the Parliament's Education Committee, and this continuity and expertise has been very beneficial to the committee, so can I particularly offer a vote of thanks to Liz for her contribution over the years to this work. Liz has been replaced by Jamie Green, and Alison Harris has been replaced by Jamie Halcrow-Johnson, who we both welcome to the committee this morning. And can I now invite Jamie Green to declare any relevant interests.
Thank you, Convener, and thank you for your warm welcome. I add my comments to yours about Liz Smith. They're big boots to fill, but I'll try my best on the committee. No formal declarations other than voluntarily that I did teach English for 2 years.
Thank you very much. And can I now invite Mr. Halcrow-Johnson to declare any interest?
Thank you very much, Convener. Again, thank you for your welcome. I have no relevant interests.
Okay, thank you. Can I our second agenda item is a decision to take a work programme in private today. Are members content to do so? Thank you. And our next agenda item is the Disclosure Scotland Bill. Today we are undertaking stage 2 consideration of the Disclosure Scotland Bill, and I welcome Minister for Children and Young People Marie Todd, MSP, and her officials to the committee this morning. Everyone should have with them a copy of the bill as introduced, the marshalled list of amendments and the groupings of amendments, which sets out the amendments in the order in which they will be debated. It may be helpful just to explain procedure briefly. There will be one debate on each group of amendments. I'll call the member who lodged the first amendment in that group to speak to and move the amendment and to speak to all other amendments in the group. I will then call for any other member who have lodged the amendments in that group. Members who have not lodged amendments in the group but who wish to speak to any of the amendments should indicate by catching my or the clerk's attention. The debate in the group will be concluded by me inviting the member who moved the first amendment in the group to wind up. Following debate in each group, I will check whether the member who moved the first amendment in the group wishes to press the vote or withdraw. If they wish to press ahead, I will put the question on the amendment. If a member wishes to withdraw an amendment after it has been moved, they must seek the agreement of the members to do so. If any member objects, the committee will immediately move to vote on the amendment. If a member does not want to move their amendment when they are called, they should say not moved. Please note that any other member present may move such an amendment. If no one moves the amendment, I will immediately call the next amendment in the marshalled list. Only committee members are allowed to vote. Voting in the division is by show of hands, and I would urge everyone to keep their hands clearly raised until the clerks have recorded the vote. The committee is required to indicate formally that it has considered and agreed each section of the bill, and so I will put each question on the section at the appropriate point. And our aim is to complete part 1 of the bill today. So if I could refer members to stage 2 convener's marshalled list, and we'll move to stage 2 proceedings. First, section 1, level 1 and level 2 disclosures, childhood convictions, alignment of state and self-disclosure provisions. So I call amendment 1 in the name of the Minister, grouped with amendments as shown in the groupings, and ask the Minister to move amendment 1 and speak to all amendments in the group.
Thank you. Good morning, Convener. I'm pleased to be moving the Government's amendments to the Disclosure Bill this morning. These amendments are reflective of the level of engagement which has continued since it was introduced and the Committee's constructive scrutiny of the bill. The first group of amendments are concerned with the rules on self-disclosure of unspent convictions under the Rehabilitation of Offenders Act 1974 and how those rules relate to the provisions in the bill on state disclosure of childhood convictions. When introducing the bill, we were aware that further changes would be needed to align the disclosure rules in the bill with the self-disclosure regime under the 1974 Act in relation to childhood convictions. If an unspent childhood conviction was not disclosable by the state, the individual should have the right to treat a question from prospective employers and others about previous convictions as excluding those relevant childhood convictions. We were therefore conscious that there had to be symmetrical provisions between the state and self-disclosure regimes to give full effect to the policy intention behind the bill. As explained to the committee at the outset, our intention has always been to address this through Stage 2 amendments. Once the changes to the 1974 Act made by the Management of Offenders Scotland Act 2019 had been enacted. The main challenge arises in relation to unspent childhood convictions, and in particular within sectors which do not routinely use the disclosure system to verify the existence of unspent convictions. If individuals only had to disclose what had been included in a disclosure product, they would in effect be exempt from self-disclosing any childhood convictions provided they never had to apply for a disclosure. The policy intention of these amendments addresses this potential safeguarding gap, while providing a truly transformative opportunity for people with offending in their childhood, consistent with the policy thrust of the bill. With these amendments, the majority of childhood convictions will immediately become spent under the 1974 Act. They would therefore not be capable of being disclosed as an unspent conviction on either Level 1 or Level 2 disclosures. The individual would not have to self-disclose these convictions if an employer asked about any past offending behaviour. This is similar to the changes made to the self-disclosure rules on the children's hearing disposals by the Management of Offenders Act. This general provision, however, will be subject to important exceptions. Public protection will be served by provisions which draw a line around the most serious forms of criminality during childhood. This most serious behaviour will remain eligible for state disclosure, and there will be a corresponding duty on the individual to self-disclose it when asked by an employer for as long as the conviction remained unspent. The conviction will appear automatically on a Level 1 or Level 2 disclosure as an unspent conviction. This exception would be for individuals where they have a conviction which resulted in a custodial sentence exceeding 48 months, known as an excluded sentence under the 1974 Act, and in the case of a sexual offence, a conviction which resulted in a custodial sentence exceeding 12 months. This approach means that much of the provisions in the bill relating to childhood convictions for Level 1 disclosures can be removed entirely. There will no longer be a decision-making process by ministers in relation to childhood convictions for the purposes of a Level 1 disclosure, since the small category of childhood convictions which will remain unspent will be disclosable automatically without any exercise of discretion for as long as they're unspent. The effect of this proposal removes all negative consequences for the individual caused by the 1974 Act with regard to childhood convictions, save for those convicted of the most serious types of offending. This is a very small minority of all those convicted in childhood. The vast majority of childhood convictions will become immediately spent and will not be disclosable either by the individual or the state in any circumstances. Taken together, this group of amendments successfully aligns the rules in self and state disclosure of unspent childhood convictions and delivers the benefits of allowing individuals to move on from their childhood offending behaviour while ensuring a suitable level of public protection for vulnerable groups. I would urge committee members to support these amendments. If members wish me to discuss the amendments in more detail, I'll be happy to do so. I move Amendment 1.
Minister, do any members wish questions? Mr Johnson?
Can I thank the Minister for that explanation? I think in broad terms that the amendments in this section make an awful lot of sense in terms of aligning the operation of this bill with other recent legislation. But I was just wanting to, basically because I'm not a lawyer, and I just want to check my understandings. And in particular, so that really what we're talking about in terms of the way that childhood convictions would be treated, that because the vast majority of childhood convictions are immediately spent, that it is the most serious. But the other, so that I just want to just clarify that and ask whether or not the Minister could just provide a little bit more by way of explanation in terms of the examples and the for instances around that. The other question I have is just, and while I understand that by doing that, in a sense, you don't need ministerial discretion because it should happen by dint of the seriousness of the offence and the conviction. I'm just wondering whether or not removing that discretion entirely, and indeed some of the routes for appeal that happen around that to the independent reviewer. I'm just wondering whether or not that is just how clear-cut that is. Are we saying that there's absolutely no grey areas because of the way that the law will now work in terms of childhood convictions? And I just that's my one area of query I think I have around that. It's just that, is it safe to have it purely on an automatic basis with no ministerial discretion and to remove those routes for review and appeal?
So, first of all, to clarify, yes, they will become spent, and secondly, there will be no grey area. I think that is reasonable. I have to say, we did give, and I gave, a great deal of thought to deciding where the line should be drawn. There is a really fine balance to be struck between policy, which helps people to move on beyond offending, and balancing that with the need to ensure the disclosure system provides a sufficient level of protection. As I've said, the changes to the 1974 Act are primarily concerned with Level 1 disclosures because there are separate rules for Level 2 to ensure the protection of vulnerable groups. And we need a provision for a limited set of rules on self-disclosure to cater for situations where someone's been convicted of the most serious offences. And in doing that, we have to remember that the same rules would have to apply to state disclosure. The more rules we add, we move further away from ending the automatic disclosure of childhood convictions on a Level 1 disclosure. So there's no straightforward answer where to draw the line. I accept that there might be different views on where the balance has been struck. I think the committee members will agree that the accepted sentences that I've proposed in these amendments cover very serious offending behaviour. And I've carefully balanced these provisions against the UNCRC principles, Article 40, which states that the requirement to promote the child's reintegration and assumption of a constructive role in society. I'm listening to members' views. I'm happy to work with you to ensure that we have the provisions that allow people to move on from their childhood offences.
Thank you, Minister. Are there any other questions? Well, Minister, do you wish to wind up?
No.
Thank you. In that case, the question is that Amendment 1 be agreed to. Are we all agreed? Yes. Thank you. I call Amendment 2 in the name of the Minister, already debated with Amendment 1. Minister, to move formally.
Moved.
The question is that Amendment 2 be agreed. Are we all agreed? The question is that Section 1 be agreed to. Are we all agreed? Thank you. Minor drafting amendments are the next to consider. Call Amendment 3 in the name of the Minister, group with amendments as shown in the groupings. The Minister to move Amendment 3 and speak to all amendments in the group.
These amendments are grouped as minor and drafting and are primarily intended to assist in clarity in reading and understanding the legislation or as a consequence of other amendments. Amendments 102 and 68 to 88 are minor technical changes, replacing the words individual and scheme member with the word applicant in relevant sections. These amendments will support consistency for those following a notional application through processes provided for in the legislation. Amendments 4 and 50 clarify in the face of the bill that an individual can only apply for a disclosure in relation to themselves. This removes any potential for ambiguity in interpretation of the legislation. Amendment 3 inserts language clarifying that ministers can refuse to issue a Level 1 disclosure product under this bill when it is more appropriate that the information would be contained in a disclosure that when it's more appropriate that the information that would be contained in the disclosure could be obtained in the form of a disclosure product from another competence authority. For instance, a basic disclosure obtained from the Disclosure and Barring Service. The existing wording may have implied that a Level 1 disclosure product as such could be obtained from a person other than the Scottish Ministers, which is not the case. Amendments 51 and 89, similar to 3, insert language clarifying the purpose of a Level 2 disclosure must be one in relation to which the protections against self-disclosure under the Rehabilitation of Offenders 1974 Act have been excluded by an order made by the Scottish Ministers. This means that where any of the protections were excluded for other purposes by an order made in another part of the UK, any disclosure application for those purposes should be directed to the appropriate UK disclosure service. Amendment 22 introduces wording to make it clear that the definition of non-disclosable conviction includes a conviction for a List B offence. Previously, this only referred to a List B offence, but it is, of course, the existence of a conviction for such an offence that brings a matter within this definition. Section 29(4)A as drafted is inconsistent in referring to the plural purposes of the disclosure. All of the other provisions refer to a singular purpose, and that is what is used in the defined term in Section 70 of the Bill. Amendment 97 is an amendment to bring that reference into line. Amendment 121 removes paragraph C from Section 69 of the Bill, which defines what is involved in consideration of suitability. The wording in paragraph C was intended to underpin Section 57(4) and the provision of advice from an umbrella body to a personal employer. However, in terms of Section 57, it is still the personal employer making the suitability assessment. Thus, they are covered by paragraph A in Section 69, rendering paragraph C unnecessary. Amendment 125 substitutes for the definition of spent conviction a new definition of spent and unspent that will apply to all convictions, including childhood convictions and cautions. This avoids the need to add a separate definition of spent childhood conviction, and the introduction of a definition of unspent in relation to the convictions enables some simplifications of the amendments relating to disclosure of childhood convictions at Section 1, and the definition of criminal disposal in Section 13(3). Amendment 126 provides a definition of the type of regulated role which is used in a few places in Part 1 of the Bill. There is no new definition in broad terms under this amendment. It simply makes it clear that the definition of the term in the PVG Act applies for the purpose of the references in Part 1 of the Bill. Amendment 200 amends the PVG Act to ensure that Scottish Ministers must issue and the Chief Constable must have regard to guidance in the exercise of their functions under Part 1 and Part 2 of the PVG Act. The Bill currently only provides this for functions under Part 1 of the Disclosure Bill. This improves consistency underpinning the approach by which information is provided by the Chief Constable. Amendment 205 and 206 fix an error in the drafting of Schedule 5, minor and consequential amendments. The amendments are intended to ensure that the power to make regulation prescribing fees covers applications to renew membership of the scheme, and that if a fee that is prescribed for an application is not paid in the manner provided for in the regulations, then the application needn't be considered. The Bill currently makes this amendment in the wrong place in Section 74, and these amendments make sure that the amendment is made in the correct place in Section 74. I move Amendment 3.
Thank you. Minister, do any members wish to contribute? No. Minister, do you wish to wind up?
No.
Thank you. In that case, the question is that Amendment 3 be agreed to. Are we all agreed? Thank you. I call Amendment 4 in the name of the Minister, already debated with Amendment 3, and ask the Minister to move formally.
Moved.
Thank you. The question is that Amendment 4 be agreed. Are we all agreed? Thank you. The question is that Section 2 be agreed. Are we all agreed? Thank you. And the question is that Section 3 and 4 be agreed. Are we all agreed? Thank you. I call Amendment 5 in the name of the Minister, already debated with the Amendment 1, and ask the Minister to move formally.
Moved.
Thank you. The question is that Amendment 5 be agreed to. Are we all agreed? Call Amendment 6 in the name of the Minister, already debated with Amendment 1, and Minister to move formally.
Moved.
Thank you. Question is that Amendment 6 be agreed to. Are we all agreed? Thank you. And question is that Sorry, the question is that Amendment 6 be agreed to. Are we all agreed? Thank you. And the next question is that Section 6 be agreed to. Are we all agreed? Thank you. I call Amendment 7 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
Thank you. The question is that Amendment 7 be agreed. Are we all agreed? Thank you. I call Amendment 8 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
Thank you. The question is that Amendment 8 be agreed to. Are we all agreed? And the question is that Section 7 be agreed. Are we all agreed? Thank you. I call Amendment 9 in the name of the Minister, already debated with Amendment 1. The Minister to move formally.
Moved.
Thank you. The question is that Amendment 9 be agreed to. Are we all agreed? Thank you. I call Amendment 10 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
Thank you. And the question is that Amendment 10 be agreed to. Are we all agreed? Call Amendment 11 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
Thank you. The question is that Amendment 11 be agreed to. Are we all agreed? Thank you. I call Amendment 12 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
Thank you. The question is that Amendment 12 be agreed to. Are we all agreed? Thank you. I call Amendments 13, 14, 15 and 16, all in the name of the Minister and previously debated. I invite the Minister to move Amendments 13 to 16 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 13 to 16? Thank you. So the question is that Amendments 13 to 16 are agreed. Are we all agreed? Thank you. The question is that Section 12 be agreed. Are we all agreed? Thank you. Call Amendment 17 in the name of the Minister, already debated with Amendment 1. Minister to move formally.
Moved.
Thank you. The question is that Amendment 17 be agreed. Are we all agreed? Thank you. I call Amendment 18 in the name of the Minister, grouped with amendments as shown as the grouping. I invite the Minister to move Amendment 18 and speak to all amendments in the group.
These amendments have been lodged in response to evidence to the committee from a number of groups who have commented on the disclosure of children's hearings disposals. The bill, as introduced, treats offending behaviour which has been addressed within the children's hearing system as a childhood conviction for the purposes of state disclosure. A number of groups have said that this is not in keeping with the ethos of a welfare-based system. The proposed amendments mean that children's hearing disposals would not be categorised as convictions for the purposes of the bill, but should otherwise be treated in the same way as spent childhood convictions in terms of the rules on when they should be included on a level 2 disclosure. They are treated as spent childhood convictions since changes introduced by the Management of Offenders Scotland Act 2019 mean that all children's hearing outcomes become spent immediately. Amendment 122 inserts a definition of children's hearing outcome. It draws on Section 3 of the Rehabilitation of Offenders Act 1974, taking a consistent approach to the definition of conviction in the bill, which also points to the 1974 Act. This reflects the link between the system of state disclosure in the bill and the system of self-disclosure in the 1974 Act. Amendment 123 then carves children's hearings outcome out of the definition of conviction. Amendment 49 then replicates Section 14 of the bill so that we still have provision for children's hearing outcomes that should be non-disclosable. We do not need to replicate Section 14(1)(a) as all children's hearing outcomes will immediately be spent because of the Management of Offenders Act. Amendment 124 is consequential. Amendment 23 also deletes subsection 3 of Section 14 as a consequence. Amendments 18 and 54 then add a provision into Sections 13 and 17 respectively, which, when read with the consequential amendments 55 to 57, 59 to 61 and 63 to 65, effectively treats children's hearings outcomes in the same way as spent childhood convictions for disclosure purposes, albeit they will be clearly badged separately to childhood convictions in any disclosure certificate. Amendments 91, 93 to 96, 99 to 101, 105 and 113 are consequential and again ensure that children's hearings outcomes are treated in the same way as spent childhood convictions for the purposes of the review and appeals processes and for the purpose of the power in Section 40 to modify other disclosure enactments. I move Amendment 18.
Thank you. Minister, do any members wish to contribute to the debate? No. Thank you. Minister, do you wish to wind up? Thank you. Therefore, the question is that Amendment 18 be agreed to. Are we all agreed? Thank you. Now move to Level 2 disclosure of other relevant information, and I call Amendment 19 in the name of the Minister, grouped with Amendment 66, 67 and 203. And I invite the Minister to move Amendment 19 and speak to all the amendments in the group.
Thank you. These amendments relate to the disclosure of other relevant information, or ORI, on a Level 2 disclosure and as vetting information for the purpose of the PVG scheme. Amendment 19 provides that ORI from an overseas police force is a category of information that may be disclosed on a Level 2 disclosure. This amendment ensures that overseas ORI can continue to be disclosed, as is currently the case, under the Police Act 1997 and the PVG Act. Section 18 of the bill already permits ORI provided by the Chief Constable of Police Scotland to be included in a Level 2 disclosure. The Scottish Government will use a Section 104 order under the Scotland Act to replicate the bill provisions for ORI provided from other UK police forces, so that the same applies to the Chief Officers of police forces across the rest of the UK. However, that order will not be able to deal with the disclosure of ORI from overseas police forces. This amendment, together with Amendment 67, will address that issue. In regards to Amendment 67, Subsection 1 places the duty on Scottish ministers before providing a Level 2 disclosure to an applicant to request the Chief Officer of every relevant overseas police force to provide ORI which meets the two-part test. The Scottish ministers cannot compel the Chief Officer of an overseas police force to engage in a statutory review process. It would not be within the competence of the Scottish Parliament to legislate for Scottish ministers to do so. Together, subsections 2 and 4 of this amendment provide that overseas ORI may only be included in a Level 2 disclosure following a direct review to the independent reviewer, including, if taken, an appeal to a sheriff against the independent reviewer's decision. Subsection 5 provides Scottish ministers with the power to make regulations about the procedural aspects of the direct review. This includes the opportunity for the applicant to make representation to the independent reviewer and an appeal to the sheriff against the independent reviewer's decision. Under the existing disclosure legislation, ORI from overseas police forces is very rare. Given how infrequently we anticipate this review process will be utilised in practice, the procedural aspects of this review process are considered too detailed for the face of the bill. Subsection 6 provides a power to prescribe relevant overseas police forces in keeping with the approach under the existing law. Amendment 66 inserts new subsections into Section 18. This amendment clarifies that information relating to a time when the applicant was under 12 years old can only be provided by the police as ORI after a determination has been made by the independent reviewer under the Age of Criminal Responsibility Act. This reflects similar provisions that the ACR Act inserted into the disclosure provisions of the Police Act and PVG Act, which are now being superseded and repealed by the disclosure provisions in this bill. Amendment 203 is a consequential amendment to the PVG Act. Section 97(5) of the PVG Act defines relevant police forces with reference to the Police Act 1997. Since the bill repeals the Police Act, it is necessary to substitute the reference to the Police Act with reference to Section 57 of the bill. The range of relevant police forces remains the same, and this ensures that the arrangements under the PVG Act for obtaining ORI as vetting information remain the same. I move Amendment 19.
Thank you. Minister, do any members wish? Mr Johnson?
So this is a little bit of a speculative question, but having read and reread the section, I mean, initially I was concerned that when the amendments were talking about overseas police forces, that was casting a very wide net. And then I realised that those overseas police forces are defined as the Channel Islands, the Isle of Man, and so on and so forth. But that also did beg the question for me, is that given that Police Scotland have access to intelligence systems, such as Interpol, again, I recognise that a line has had to be drawn in terms of what can practically be done. But I was just wondering kind of what consideration when drawing this up was given by the government to looking at intelligence and information that may be accessible or indeed held by Police Scotland, but obtained from police forces beyond those defined as overseas police forces.
So can I just clarify, you're talking about information which is accessible for Police Scotland, and it would be for Police Scotland to then disclose under these circumstances, yeah?
It just strikes me that an individual may well have committed offences or come into contact with police forces outside the jurisdictions of the forces defined within these amendments. That is obviously potentially information that's of concern, certainly information that's potentially relevant given the considerations, but obviously wouldn't be caught by these. So given that the government has expanded, in a sense, the number of jurisdictions and the number of police forces from whom they can draw information and is disclosable, albeit to simply the Channel Islands and so on. I was just wondering what consideration had been given to looking at information and conviction information in other jurisdictions altogether, and whether or not that had formed part of the work that had gone into these amendments.
Yes, it is. The situation is that that overseas information goes through one single police force in the UK, Hampshire Police, and then that is then used in the system as described. So it comes into the UK through that single police force and then is used as described in the legislation.
It's helpful clarification.
Thank you. Any other members wish to come in? Mr. Gray?
Just on a similar point of clarification, so if somebody was applying for disclosure and other relevant information had been provided, they would have the opportunity to have that reviewed, whether it was appropriate or not, and they would know the source of that information then?
Yes, they would.
Any? Yeah, Mr. Gray?
Just one additional point based on that. There's interesting comments there. If information was not captured through the relevant authority, I think you said Hampshire, but and disclosure was given to an individual, but information came to light later after disclosure had been given, what powers of revocation are available in order to, if further information comes from perhaps police forces which had not been linked up to the system?
That would be covered by the ongoing monitoring requirements of the PVG scheme membership.
Minister, do you wish to wind up? Thank you. The question is that Amendment 19 be agreed to. Are we all agreed? Thank you. Call Amendment 20 in the name of the Minister, already debated with Amendment 1, and ask the Minister to move formally.
Moved.
The question is that Amendment 20 be agreed. Are we all agreed? Thank you. Call Amendment 21 in the name of the Minister, already debated with Amendment 1, and ask the Minister to move formally.
Moved.
Thank you. The question is that Amendment 21 be agreed. Are we all agreed? And the question is that Section 13 be agreed to. Are we all agreed? Thank you. Call Amendment 22 in the name of the Minister, already debated with Amendment 3. Minister to move formally.
Moved.
Thank you. The question is that Amendment 22 be agreed to. Are we all agreed? Thank you. Call Amendment 23 in the name of the Minister, already debated with Amendment 18, and invite the Minister to move formally.
Moved.
Thank you. The question is that Amendment 23 be agreed. Are we all agreed? Thank you. The question is that Section 14 be agreed to. Are we all agreed? Thank you. We now move to List A and List B offences, miscellaneous amendments. I call Amendment 24 in the name of the Minister, grouped with amendments as shown in the groupings. And I invite the Minister to move Amendment 24 and speak to all amendments in the group.
Thank you, Convener. These amendments relate to the offence lists in Schedule 1 and 2 of the Bill, known also as Lists A and List B. Convictions for offences in Schedules 1 and 2 will continue to be disclosed on Level 2 disclosures until a successful review, or in the case of a conviction for an offence in Schedule 2, it becomes non-disclosable under Section 14. These amendments update the offence lists in the schedules with recently amended and newly created statutory offences. The amendments to Schedule 1 and 2 also respond to requests from the Crown Office and Procurator Fiscal Service on behalf of the Judicial Appointments Board for Scotland that offences relating to dishonesty, the administration of justice and integrity be moved to Schedule 1. The changes cover dishonesty offences against an individual, breach of trust or responsibility or misconduct in a position of authority. Moving these offences from List B to List A will mean that they will be disclosable for longer even after they are spent. This is intended to promote the integrity of the justice system in Scotland. Separately, there are a number of recently amended or newly created statutory offences which have recently received royal assent that warrant inclusion on the offence lists. These have been situated in the lists alongside similar offences currently in Schedule 1 or 2, taking into account the factors described in paragraph 119 of the Policy Memorandum. I move Amendment 24.
Thank you, Minister. Does any member wish to ask a question or debate? Thank you. Minister, do you wish to wind up?
No, thank you.
Okay. The question is that Amendment 24 be agreed. Are we all agreed? Thank you. I call amendments 25 to 35, all in the name of the Minister and all previously debated, and invite the Ministers to move amendments 25 to 35 en bloc.
Moved en bloc.
Does any member object to a single question being put on amendments 25 to 35? Thank you. The question is that amendments 25 to 35 are agreed. Are we all agreed? Now move to PVG Act, carrying out a regulated role without being a scheme member. I call Amendment 36 in the name of the Minister, grouped with Amendments 146, 147, 148 and 149, and invite the Minister to move the amendment and speak to all the amendments in the group.
Thank you, Convener. These amendments relate to offences to be inserted into the PVG Act by the Bill in connection with the mandatory PVG scheme. Amendment 36 is consequential, so although it leads the group, I will discuss it last. Amendment 146 removes the words seek or from the offence in new section 45C1 inserted into the PVG Act by section 74 of the Bill. This is necessary to make it clear that the act of applying for a job before being a scheme member will not be regarded as a criminal offence. The amendment does not adversely impact the requirement for those actually carrying out a regulated role to be in the mandatory PVG scheme. It will also be an offence for an individual to agree to carry out a regulated role without being a PVG scheme member. Amendment 147 inserts a new provision into the new section 45C of the PVG Act. This makes clear in relation to the offence under subsection 1 of agreeing to carry out a regulated role without being a scheme member that an individual is not deemed to have agreed to carry out a regulated role if that agreement is subject to the individual joining the PVG scheme for that type of role. There is already a similar provision in new section 45D2 for employers, and it is only right that the same treatment is extended to individuals so that they may apply for the role without being a scheme member, but only agree to take up employment and start in the role once they have successfully joined the scheme. Amendment 148 provides the Scottish Ministers with a regulation making power to prohibit organisations from permitting an individual to carry out a regulated role or to require organisations to remove an individual from a regulated role where the individual is not a scheme member. This is to address behaviour by organisations continuing to employ someone to carry out a regulated role where that person is not or is no longer a scheme member. Regulations may impose prohibitions or requirements in relation to particular types of organisations or in relation to particular kinds of regulated roles. Subsection 3 makes it an offence for an organisation to fail to comply with regulations made under this subsection 1, although it will be a defence for an organisation to prove that they did not know and could not reasonably be expected to have known that the individual was not a scheme member. This amendment ensures that there is ongoing impetus in organisations to check whether their employees remain scheme members. It ensures that there is a consequence for any organisation that does nothing following the receipt of a notification under the new section 45B stating that a scheme member's membership has lapsed. Under the bill as introduced, in the situation where a scheme member's membership has lapsed and they continue to carry out a regulated role, only the individual will be committing an offence. Amendment 148 means that there would be an equivalent offence for organisations who failed to comply with any prohibition or requirement imposed by regulations. Amendment 149 applies the same penalties to the new offence created by Amendment 148 as are set out in the new section 45F of the PVG Act. This is appropriate as all of the offences introduced by section 74 of the bill deal with the same conduct, namely evading the mandatory PVG scheme. The offences in the new section 45C, 45D and 45E inserted by the bill into the PVG Act are all included in the list of offences in Schedule 1, the List A offences, which can continue to be disclosed on Level 2 disclosures even after they are spent. Amendment 36, for consistency, adds the new offence proposed by Amendment 148 to Schedule 1. I move Amendment 36.
Thank you. Minister. Jenny, Membership, Mr Gray.
Sorry, this is perhaps my fault for not reading, and you did kind of allude to this, Minister, but I just wanted a little more clarity on the sanctions that are available when these powers are used against an organisation which has continued to use individuals in regulated roles without membership.
So the Amendment 149, as I said, applies the same penalties to the new offence created by Amendment 148. So the sanctions that we're introducing today align with the sanctions already previously alluded to. If you just give me 1 second, I'll get the specific details. So the penalties for offences relating to regulated roles by individuals not in the scheme are on summary conviction to imprisonment for a term not exceeding 12 months or a fine not exceeding the statutory minimum or both, and B, on conviction on indictment to imprisonment for a term not exceeding 5 years or a fine or both.
Presumably in the case of the organisation, the employer, rather than the individual, that would apply how to the legal personality of whatever the organisation was, whatever its structure was.
So there's a provision in the PVG Act about corporate offences, so that's where it would apply.
Thank you.
Mr Gray.
Thank you. Can I just ask as a general, and apologies if this was covered at stage 1, but how much this is a shift from the status quo? Is this giving ministers additional powers to hold organisations to account more than individuals, or to give them greater power to create offences which are relevant to individuals rather than the umbrella organisations which they sit? Another point, Minister, would be these regulations under Subsection 1 in Amendment 148, what parliamentary scrutiny will be afforded to the committee or the Parliament when ministers create such regulations. And my final point would be guidance, and that's what guidance will be given to organisations who perhaps are currently made up of mixed personnel who are PVG and non-PVG individuals, and if there will be any changes in their perceptions to how these regulations will affect them, specifically to address any concerns around changes in the law.
Okay. So the balance is pretty similar between the individual and the organisation, and these requirements are introduced by the fact of the scheme becoming mandatory. There will be a great deal of guidance issued to ensure that everybody is aware of the change that is coming and what they are required to do in terms of their duties. There also will be built into the system reminders and things. We're not intending to criminalise a large number of people. What we're intending to do is have a secure scheme that is easily operable by the general public and easily understood, and we will endeavour to make sure that that's what we deliver. Did you ask about scrutiny of guidance?
Yeah, it regulates. So if ministers, for example, change the details of types of organisations or the types of regulated roles that these offences cover, what scrutiny that will be afforded to those.
They're negative regulations.
Okay, thank you.
Okay. Minister, do you wish to wind up?
No, thank you.
Thank you. The question is that Amendment 36 be agreed to. Are we all agreed? The question is that Schedule 1 be agreed to. Are we all agreed? Thank you. Call Amendment 37 to 48, all in the name of the Minister and all previously debated, and invite the Minister to move Amendments 37 to 48 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 37 to 48? The question is therefore is that Amendments 37 to 48 are agreed. Are we all agreed? Thank you. The question is that Schedule 2 be agreed to. Are we all agreed? Thank you. I call Amendment 49 in the name of the Minister, already debated with Amendment 18, and Minister to move formally.
Moved.
Thank you. The question is that Amendment 49 be agreed to. Are we all agreed? Call Amendment 50 in the name of the Minister, already debated with Amendment 3, and ask the Minister to move formally.
Moved.
Thank you. The question is that Amendment 50 be agreed. Are we all agreed? The question is that Section 15 be agreed to. Are we all agreed? Call Amendment 51 in the name of the Minister, already debated with Amendment 3, and ask the Minister to move formally.
Moved.
Okay. The question is that Amendment 51 be agreed to. Are we all agreed? And the question is that Section 16 be agreed. Are we all agreed? Call Amendments 52 to 65 in the name of the Minister and all previously debated, and invite the Minister to move Amendments 52 to 65 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put on Amendments 52 to 65? The question is that Amendments 52 to 65 are agreed. Are we all agreed? Thank you. The question is that Section 17 be agreed. Are we all agreed? Call Amendment 66 in the name of the Minister, already debated with Amendment 19, and ask the Minister to move formally.
Moved.
Thank you. Question is that Amendment 66 be agreed to. Are we all agreed? And the question is that Section 18 be agreed to. Are we all agreed? Thank you. Call Amendment 67 in the name of the Minister, already debated with Amendment 19, and ask the Minister to move formally.
Moved.
Thank you. The question is that Amendment 67 be agreed. Are we all agreed? Call Amendment 68 to 80, all in the name of the Minister and all previously debated, and invite the Minister to move Amendments 68 to 80 en bloc.
Moved en bloc.
Does any member object to a single question being put to Amendments 68 to 80? The question is that Amendments 68 to 80 are agreed. Are we all agreed? Thank you. Question is that Section 19 be agreed. Are we all agreed? I call Amendments 81 to 88, all in the name of the Minister and all previously debated, and invite the Minister to move Amendments 81 to 88 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put on Amendments 81 to 88? The question is that Amendments 81 to 88 are agreed. Are we all agreed? The question is that Section 20 be agreed. Are we all agreed? And the question is that Section 21 be agreed. Are we all agreed? Thank you. Call Amendment 89 in the name of the Minister, already debated with Amendment 3, and ask the Minister to move formally.
Moved.
Thank you. The question is that Amendment 89 be agreed to. Are we all agreed? The question is that Section 22 be agreed to. Are we all agreed? Thank you. Call Amendment 90 in the name of the Minister, already debated with Amendment 1, and ask the Minister to move formally.
Moved.
The question is that Amendment 90 be agreed to. Are we all agreed? Call Amendment 91 in the name of the Minister, already debated with Amendment 18, and ask the Minister to move formally.
Moved.
Thank you. Question is that Amendment 91 be agreed to. Are we all agreed? The question is that Section 23 be agreed. Are we all agreed? And the question is that Section 24 be agreed. Are we all agreed? I call Amendments 92 to 96, all in the name of the Minister and all previously debated, and invite the Minister to move 92 to 96 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put to the amendment 92 to 96? No, the question is that amendments 92 to 96 are agreed. Are we all agreed? The question is that section 25 be agreed to. Are we all agreed? And the question is that section 26 to 28 be agreed to. Are we all agreed? Call amendments 97 in the name of the Minister, already debated with Amendment 3. Minister to move formally.
Moved.
Thank you. Question is that Amendment 97 be agreed. Are we all agreed? And the question is that section 29 be agreed to. Are we all agreed? And the question is that section 30 be agreed to. Are we all agreed? I call amendments 98 to 102 in the name of the Minister and all previously debated, and invite the Minister to move amendments 98 to 102 on block.
Moved en bloc.
Thank you. Does any member object to a single question being put on amendments 98 to 102? Thank you. The question is that amendments 98 to 102 are agreed to. Are we all agreed? Thank you. The question is that section 31 be agreed. Are we all agreed? And the question is that section 32 be agreed. Are we all agreed? Thank you. Now move to level 2, disclosure process after independent review. I call amendment 103 in the name of the Minister, grouped with amendments 104, 106, 107, 108, 109 and 110. And I invite the Minister to move amendment 103 and speak to all the amendments in the group.
Thank you, Convener. I'm pleased to move amendments introducing a right to subsequent review for disclosure applicants where there was a previous decision to include information. As recommended by the committee at stage 1, Amendment 106 will provide this ability. The purpose of subsection 5 in the original drafting is to ensure that following a successful review, the same information would be excluded from a subsequent level 2. However, its effect was that there is not a recourse for subsequent review and inclusion. This amendment allows for such subsequent review in appropriate circumstances. Amendment 103, 104, 107 and 108 relate to a Chief Constable's right of appeal against a decision by the independent reviewer and how that affects the timescales for the reviewing process coming to an end. Where the Chief Constable has a right to appeal to the Sheriff against the decision of the independent reviewer to remove ORI from a level 2 disclosure, the Chief Constable can inform ministers they will not be pursuing such an appeal and therefore allow the earlier conclusion of review proceedings. This mirrors the existing ability in the bill for the applicant to notify ministers that they do not intend to pursue an appeal. Amendment 109 is consequential to Amendment 110. Together, these amendments relate to how information removed after a review is treated for the purposes of the PVG scheme. Amendment 110 introduces language clarifying that ministers must remove the information from the applicant's scheme record and that the excluded information will no longer amount to vetting information within the meaning of Section 49(1) of the PVG Act. The significance of this is that vetting information can trigger a consideration for listing under Section 12. The amendment will ensure that this information, which has been removed from a Level 2 disclosure following the review process, cannot be used to commence a consideration for listing. I move Amendment 103.
Thank you. Minister, does any member have any questions or debate points? Thank you. Minister, would you like to wind up?
No, thank you.
The question is that Amendment 103 be agreed to. Are we all agreed? I call Amendment 104 in the name of the Minister, already debated with Amendment 103, and ask the Minister to move formally.
Moved.
The question is that Amendment 104 be agreed. Are we all agreed? I call Amendment 105 in the name of the Minister, already debated with Amendment 18, and ask the Minister to move formally.
Moved.
The question is that Amendment 105 be agreed. Are we all agreed? Thank you. The question is that Section 33 be agreed to. Are we all agreed? I call Amendment 106 to 110 in the name of the Minister, all previously debated, and invite the Minister to move 106 to 110 on block.
Moved on block.
Does any member object to a single question being put on Amendments 106 to 110? The question is that Amendments 106 to 110 are agreed. Are we all agreed? The question is that Section 34 be agreed to. Are we all agreed? We now move to Level 2 disclosure, spent childhood convictions and children's hearing outcomes, disapplication of Section 4 of the Rehabilitation of Offenders Act 1974. And I call Amendment 111 in the name of the Minister in a group on its own, and I invite the Minister to speak to Amendment 111.
Thank you, Convener. Amendment 111 inserts a new section into the bill. It is modelled on Section 8 of the Age of Criminal Responsibility Scotland Act 2019. This amendment provides that for any referral to the independent reviewer made under Section 25 of the bill in respect of spent childhood convictions or children's hearing outcomes, the protections against self-disclosure under Section 4 of the Rehabilitation of Offenders 1974 Act would be disapplied for the purpose of this referral, including any appeal to a sheriff under Section 33. What this means in broad terms is that a person who has asked for a review has to answer questions and provide information about their spent childhood convictions or children's hearing outcomes for the purposes of the review process. I move Amendment 111.
Thank you, Minister. Do any members have any questions? Comments? Thank you. Minister, do you wish to wind up?
No, thank you.
Thank you. The question is that Amendment 111 be agreed to. Are we all agreed? Thank you. We now move to disclosure, principles for decision making, and I call Amendment 112 in the name of the Minister, grouped with amendments 208, 221 and 202. I can invite the Minister to move Amendment 112 and speak to all the amendments in the book group.
Thank you, Convener. These amendments have been lodged in response to feedback received from stakeholders and the committee's recommendation in its Stage 1 report on including a set of guiding principles or criteria in the bill for the application of the two-part test for inclusion of certain information in disclosure certificates. In particular, I thank Daniel Johnson for his close scrutiny of this matter. The fact that we have both lodged amendments seeking to achieve similar policy outcomes demonstrates that the Scottish Government has listened and responded to his calls for more detail on the two-part test to be on the face of the bill. Amendment 112 in my name provides two lists of matters which may be taken into account when either the Scottish Ministers, the independent reviewer or the Chief Constable are applying the two-part test for the various purposes to which it applies in the bill. The matters listed are based on and seek to reflect the factors which have been highlighted in significant case law. As there are two parts to the test, relevant and ought to be included, there is considerable overlap between subsections 2 and 3 of the new section added by this amendment. This is already acknowledged in the case law on which the factors are based. There is broad discretion for decision makers about how to take account of these matters in practice. Subsections 2 and 3 are both framed as matters which may be taken into account. There is no duty to take account of all of the matters listed. This is particularly important as not every factor will necessarily be pertinent to every decision that is made under the two-part test, and we do not want to create a duty for decision makers to have to consider or rule out every factor. Such an outcome could prolong the disclosure application process, a situation which the Scottish Government is keen to avoid. Subsections 2 and 3 also provide that the matters listed in each subsection are non-exhaustive. This ensures that other relevant matters can be taken into account so that the discretion of the decision maker is not fettered. This is vitally important within the context of the guidance which will be developed in collaboration with stakeholders. I am certain that stakeholders will have views on other factors which should form part of the decision-making process and want that to be part of the guidance. It is crucial that the provisions do not shackle that engagement and the guidance or prevent decision makers from taking a targeted approach to each case before them. Subsection 4 explains that references to other information means ORI. Subsection 5 enables both sets of matters to be amended by secondary legislation. This regulation-making power will come under Section 87(4) of the bill and will therefore be subject to the negative procedure. The Scottish Government considers this to be appropriate as it will allow ministers to respond quickly and flexibly to any significant developments in case law. Amendment 202 in my name extends the application of the new decision-making factors in Amendment 112 when the Chief Constable is considering the same two-part test in relation to the provision of ORI for inclusion in a person's scheme record under the PVG Act. In addition, the independent reviewer applies the same two-part test under the Age of Criminal Responsibility Act in relation to a decision about the inclusion of pre-12 behaviour as ORI in a disclosure certificate. Amendment 204 in my name, which we'll come to in a later group, will ensure that the decision-making principles are applied consistently across all three pieces of legislation. I urge members to accept the amendments in my name in this group. As I've said, Daniel Johnson's amendments achieve similar policy outcomes to the amendments in my name. There are two main areas of difference. The first is that Amendment 208 would impose a duty on decision makers to have regard to the matters specified in subsection 4 and 5, whereas Amendment 112 gives them discretion about which matters to take into account. The Scottish Government thinks it is more appropriate to allow this flexibility, as not all of the matters will necessarily be relevant to every decision. Another area where we take a different view is the manner in which the decision-making principles can be amended through secondary legislation. On Amendment 221, Daniel Johnson proposes that the matters will be amendable by affirmative procedure. The amendment in my name proposes negative procedure. This is essentially an administration function of ministers to ensure that the principles keep pace with any developments in jurisprudence. We think it would be appropriate to have this regulation making power subject to the negative procedure. The default rule in section 87.4 of the bill would therefore apply. I ask Daniel Johnson not to press his amendment 208. I hope that he can see that I've taken into account his close scrutiny of this issue and that the amendments in my name address his concerns about the two-part test. Moreover, the amendments in my name are all connected, ensuring that the decision-making principles are applied equally across the bill and the ACR and PVG Acts. I move Amendment 112 in my name and urge members to support that and the other amendments in my name in this group. If they are pressed to a vote, I would ask members to reject Daniel Johnson's other amendments in this group.
Thank you, Minister. Can I invite Mr Johnson to speak to Amendment 208 and the other amendments in the group?
Thank you, Convener. And can I begin by thanking the Minister for both acknowledging the issues that I've raised and for also meeting with me to discuss these matters. And I'll be relatively brief because, as the Minister points out, her amendments and mine largely do the same work and have the same effect. And so to that end, I won't be pressing my amendments, but I would just like to make a couple of very small points. But moreover, before I do, I think the importance of putting the principles on the face of the bill in terms of, I think, clarity and I think providing certainty, I think, are important. But I also think that the amendments in the Minister's name also do achieve important flexibility, as I think it is important to recognise that these things cannot be rigid and also that they will evolve. And I think that it's important that whatever we do in this regard reflects that. And I think that the Minister's amendments do that. There's two small points I'd like to make. First of all, as an opposition member and indeed a backbencher, I will always advocate the use of the affirmative procedure over the negative. And actually, I think there is an important and substantive point here. Given that I think the materiality of these points to how these decisions will be made, I think ensuring that there's adequate parliamentary scrutiny of these principles, if they are changed and they are altered by ministers, is important. But that's essentially a detail and certainly not an issue that I'm going to die in a ditch over today. The other point is more of a reflective point. I was interested to note the similarities between the Minister's amendments and my amendments. The one slight difference is that I think in my amendments I expand on kind of the materiality decisions. So, for example, in my amendment 208 4A, I then my amendment elaborates on the sort of the material considerations in terms of the nature of the conviction, and I recognise that is largely the same in the Minister's amendments, for example, 1122A. But I would wonder whether the elaboration is helpful in terms of the nature of the crimes that are considered. Because when we're looking at the relevance and ought tests, the relevance test is, I think, essentially about the materiality of the crime, the nature of the crime, and whether it's relevant to the considerations at hand. Whereas the ought is around the circumstances and therefore whether it is a pertinent thing to disclose those. So that's my one reflection. I'm not sure I'm of a fixed view that necessarily that makes my amendments significantly better, but I think it's one point of difference that I just wanted to note and maybe something to consider through stage 3. But otherwise, I'm very happy with the government's amendments and I won't be pressing my amendments.
On to
So certainly we can expand to the points that you raise in the guidance that we produce, and I'm more than happy to work with you between now and stage 3 to make sure that we arrive at something that all of us are happy with.
Thank you. Does any member wish to contribute to the debate? No. Minister, do you wish to wind up further? Thank you. The question is that Amendment 112 be agreed to. Are we all agreed? The question is that Section 35 to 39 be agreed. Are we all agreed? I call Amendment 113 in the name of the Minister, already debated with Amendment 18, and ask the Minister to move formally.
Moved.
The question is that Amendment 113 be agreed to. Are we all agreed? The question is that Section 40 be agreed. Are we all agreed? And the question is that Section 41 to 50 be agreed. Are we all agreed? Thank you. We now move to accredited bodies. I call Amendment 114 in the name of the Minister, grouped with Amendments 115, 116, 117, 118, 119 and 120. And I ask the Minister to move Amendment 114 and speak to all the amendments in the group.
Thank you, Convener. These amendments relate to the role of accredited bodies under the bill. Amendments 114 and 115 introduce a sanction, removal from the register for an accredited body which does not comply with the duty to have a lead signatory. A duty without this sanction would render the provisions in Section 51 less effective. Amendment 118 gives an applicant for registration in the Register of Accredited Bodies the power to nominate one or more counter-signatories rather than requiring them to nominate counter-signatories. Amendment 116 and 117 are consequential drafting amendments. They ensure that the existing duty under the bill to nominate a lead signatory remains in place while accommodating the conversion of the duty to nominate counter-signatories into a power to do so. Amendment 119 are also consequential. They remove the subsections 8 and 9 in section 52 of the bill. Subsection 8 imposes a requirement to have at least one counter-signatory, but since the only duty now will be to have a lead signatory at all times with a power to nominate counter-signatories also, subsection 8 is not appropriate. Subsection 9 is redundant as the definition of lead signatory under subsection 1 makes it clear that the lead signatory has authority to act as counter-signatory. Amendment 120 reframes the duty on an accredited body acting as an umbrella body when deciding what information may be shared with an organisational employer. Instead of requiring the accredited body to be satisfied that the individual is suitable to have access to the information, the accredited body will need to be satisfied that disclosure to that person would comply with the code of practice that will be published under section 56. This will make it clearer to accredited bodies what is expected of them. I move Amendment 114.
Thank you. Minister, do members have any comments? No. Minister, do you wish to wind up? No. Thank you. The question is that Amendment 114 be agreed to. Are we all agreed? I call Amendment 115 in the name of the Minister, already debated with Amendment 114, and I invite Minister to move formally.
Moved.
The question is that Amendment 115 be agreed to. Are we all agreed? And the question is that Section 51 be agreed to. Are we all agreed? I call Amendment 116 to 119 in the name of the Minister, all previously debated, and invite the Minister to move Amendments 116 to 119 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 116 to 119? Then the question is that Amendments 116 to 119 are agreed. Are we all agreed? The question is that Section 52 be agreed to. Are we all agreed? And the question is that Section 53 to 56 be agreed to. Are we all agreed? I call Amendment 120 in the name of the Minister, already debated with Amendment 114. I invite the Minister to move formally.
Moved.
Thank you. The question is that Amendment 120 be agreed to. Are we all agreed? And the question is that Section 57 be agreed. Are we all agreed? And the question is that Section 58 to 63 be agreed. Are we all agreed? Thank you. And I call Amendment 208 in the name of Daniel Johnson, already debated with Amendment 112. Mr Johnson, to move or not move?
Not move.
Thank you. The question is that Section 64 to 68 be agreed. Are we all agreed? Thank you. I call Amendment 121 in the name of the Minister, already debated with Amendment 3, and invite the Minister to move formally.
Moved.
Question is that Amendment 121 be agreed to. Are we all agreed? And the question is that Section 69 be agreed to. Are we all agreed? I call Amendments 122 to 126, all in the name of the Minister and all previously debated, and invite the Minister to move Amendments 122 to 126 en bloc.
Moved en bloc.
Thank you. Does any member object to a single question being put on these amendments? Then the question is that Amendment 122 to 126 is agreed. Are we all agreed? Thank you. Question is that Section 70 be agreed to. Are we all agree? Right, and that brings us to the end of day one, consideration of the bill. Our next meeting will be on Wednesday, the 11th of March. The target will be to complete stage 2 consideration of the bill on that day. Any further amendments to the remaining provisions of the bill must be lodged with the clerks in the legislation team by 12 noon on Thursday, the 5th of March. And that concludes our public session for this week, and we'll suspend for a few moments and move into private session.